Ladies and gentlemen, Madam Minister, Mr. President, thank you for invitation. It's always honor for me. I would like to present the topic of the rule of law from the perspective of the Venice Commission, a body which I have the honor of being a member of. I know that my presentation is the last before the coffee break, but I am hoping for your kind attention. Venice Commission, the European Commission for Democracy Through Law, commonly known as the Venice Commission, was established in 1990. The emergence of the Venice Commission was connected with the need to provide the answers to the transition from the communist to the democracy in the Central and Eastern Europe. The Commission is an independent advisory body that cooperates with the member states of the Council of Europe, as well as with interested third countries and interested international organizations and bodies. The Venice Commission maybe a few points about Venice Commission. Venice Commission has a purely consultative competence. Doesn't impose its solutions, but adopts a non-directive approach based on dialogue. Issues recommendations that are not legally binding and can formally be regarded as know-how type of assistance. Has no systematic instruments to assess whether the opinion it published are implemented in the countries it has advised. I will return to these rules later on in my speech. In the course of the 13 years of its operation, the Venice Commission has provided advice and legal assistance that it sees as relevant and valuable to member states. In this way, it became an independent and widely respected international institution in the field of rule of law, an important point of reference. The direct effects that can be attributed to the Venice Commission reports and opinions are difficult to measure. However, there is a general consensus as to the role of the Venice Commission as one of the main authority bodies in the field of human rights, democracy, and the rule of law, setting standards for others. The Venice Commission encouraged member states to adapt their national legal system to international standards, for example, by issuing documents that set up these standards, such as codes of good practice, guidelines, or checklists. The first checklist about rule of law was prepared by Venice Commission in 2011. Following the Council of Europe Parliamentary Assembly resolution, which drew attention to the need to ensure the correct interpretation of terms rule of law, Rechtsstaat, état de droit, as a free, completely or very similar but a different institution, which drew attention to this problem, how to understand such institution. As pointed out in the report, the concept of the rule of law has not been developed in legal text and legal practice to the same extent as the other pillars of the Council of Europe, human rights and democracy. And legal provisions relating to the rule of law, whether at the national and international level, are very general and do not define this concept in detail. The report also expressed doubts about the actual usefulness of the rule of law as a practical legal concept. We are still talking about 2011 year. However, it was observed that since this concept is increasingly being taken into consideration in national and international legal texts and jurisprudence, especially that of the European Court of Human Rights, this raises the need to agree on some standards. The authors on the report point out that the modern concept of the rule of law is the result of a key of different systems. At that time, it was already emphasized that the A continental legal culture has the principle of a legal state, Rechtsstaat, where the protection against the absolutist state should be provided by the legislators, and which is distinguished from the principle of the rule of law originating coming from the Anglo-Saxon legal culture, where such protection is to be provided by courts. The authors acknowledge that these concepts partially have a common meanings, but they are diametrically different in the certain aspects. However, it was decided that there is a consensus as to the core meaning of the rule of law and the elements contained in it. In other words, the report doesn't formulate a single binding definition, but refers to the elements that make up what is expressed in the concept of rule of law. We got the 6 elements. These elements established in the report 2011 was as follows on the slide. Since the 2011 report was aimed at facilitating a correct and consistent understanding and interpretation of the concept of rule of law, and as such aimed at facilitating the practical application of the rule of law, it came with an attachment checklist for evaluating of the state of the rule of law in single state, listing these 6 elements broken down into a number of sub-parameters, some kind of checking, additional checking question. In the subsequent and current Venice Commission report reference to the starting concepts, this reference to the starting concepts was made only through a brief mention that the first report relied on them. This, a curious phenomenon occurred, namely that the checklist began to live a life of its own. So with almost no connection with, direct connection with Rechtsstaat or état de droit or typical rule of law. Further, work was also fostered by a change in the approach adopted by European institutions. In 2011, a Council of the European Union started to implement a new dialogue on the rule of law with member states. And this new EU framework strengthened the rule of law, established an early warning tool based on indication received from the available sources and recognized institutions, which significantly changed the role of the Venice Commission. The 2016 report proposed new checklist to provide a tool for assessing the rule of law in the country from the perspective of its constitutional and legal structures, existing legislation, and existing jurisprudence. The checklist aimed at enabling an objective, thought, transparent, and equal assessment. However, the document also contained 3 important caveats. Firstly, it was pointed out that the rule of law is realized through successive levels achieved in the progressive manner. Full achievement of the rule of law remains on ongoing task, even in the well-established democracies. In this context, it should be clear that the parameters of the checklist don't necessarily all have to be cumulatively fulfilled in order to the final assessment on complaints with the rule of law to be positive. Secondly, the checklist is neither exhaustive nor final. It aims to cover the core elements of the rule of law. The checklist could change over the time. Thirdly, although the rule of law has become a global idea and inspiration, this does not mean that its implementation has to be identical regardless of the concrete judicial, historical, political, social, and geographical context. While the main elements or ingredients of the rule of law are constant, the specific manner in which they are realized may vary depending on the local context. These caveats are very often forgotten. My observation of the work carried out by the Venice Commission allow me to add another caveat evident in practice. The assessment of the degree of compliance with the individual elements of the checklist depends on whether we are dealing with a young or the old democracy. The current checklist is more extensive and detailed than the one contained in the earlier report. We got only 5 elements, but I was talking about this additional question, and these new subparameters have been added to these elements, and the elements have been significantly expanded. So this is a very short story about checklist made by Venice Commission. Further on, I will attempt to answer 2 questions. First one, there is a question, is the rule of law checklist used in the practice of a European institution? And the second question, how is this checklist used secondarily once implemented in individual Venice Commission reports? The fundamental answer to the first question is yes, but with some provisions. It should be remembered that the checklist is only one of several tools to assess the rule of law, in addition to the Convention and the jurisprudence of the European Court of Human Rights, not to mention other sources. Currently, the checklist is not widely used or invoked in documents prepared by the European Commission. For example, in the 2012 European Commission Rule of Law report, the checklist from Venice Commission is mentioned only twice. There is no reference in the checklist to the checklist in the European Commission Rule of Law reports for 2021 and 2022. If we juxtapose the content of these reports to the Venice Commission checklist, it should be pointed out that they don't overlap in content. One clear example of this is the fact that the 2012 report, for instance, includes the freedom of expression or the normative regulation concerning sexual minorities. These are important issues, but they concern other legal problems. They don't concern the rule of law in the strict sense. The Venice Commission's report of 2011, I mean this first one, already pointed out that respect for the rule of law and respect for human rights are not necessarily synonymous. These 2 concepts largely overlap. There are human rights inherent in the rule of law, such as the right to access to a court, nebis in idem, etc. But this don't mean that all human rights will fall under the concept of rule of law. Next problem. Some criteria in the checklist are developed by the European Commission in its report, not necessarily in the right direction. For example, the 2020 report adds judicial experience as a criterion for assessing judicial independence and autonomy. This would undermine judicial appointments of individuals who are appointed to the judiciary from other legal professions or the academic community. In the same time, it is noted in the legal scholarship that a certain level of migration between the legal profession or academia and the practice of law is desirable in view of value of a rule of law. It adds flexibility to judicial person, change interpretation habits, and so on. This is only a few examples of the problems if we compare the checklist from Venice Commission and European report about rule of law. Now let me address the second issue, namely how the various Venice Commission reports which make use of the checklist are used secondarily. To begin with, as a result of a number of factors, the opinions issued by the Venice Commissions have effectively changed their original role. Instead of being an advisory opinion, instead only to signal certain identifier or hypothetical problems, its opinion started to be viewed as reports that identify specific violation. Subsequently, on the basis of this peculiarly understood evidence of violation, further action is taken, this time by other bodies, not only bodies of the Council of Europe, but without any further examination of the circumstances concerned. I have already mentioned the Venice Commission has an advisory role. It assumes the role similar to the caring mother telling her child not to go near the fire because the child might be burned. Therefore, the role of the Venice Commission is to point out not only the shortcomings it has identified, but also any concerns, even the most hypothetical ones. Unfortunately, this aspect is not identified earlier. The highly hypothetical possibility of an effect, once signaled, are repeated in subsequent documents, regardless of whether it was occurred or not, without any assessment, and it's therefore accepted by everyone as a fact. A similar effect is related to precautionary policy adopted in opinion making. Even if the members of the Venice Commission accept the clarification of certain doubts that will include, as a precautionary measure, certainly reservation in the body of the opinion, for example, with the proviso, some point out, which, if the opinion is used in practice, is taken as another infringement that has been identified. Next problem. We must remember that the work of the Venice Commission is closer in nature, not always, but very often, is closer in nature to some kind of pre-legislative check. If the Venice Commission receives an early draft of legislation, and it will assess the context of that early draft. However, what may happen, and even should happen, is that such a draft is later amended and something else emerges in the legislative process, taking the Venice Commission's remarks on board. However, the Commission doesn't prepare any evaluation report, and only the earlier report remains in circulation. What's happened in such situation is that the Venice Commission's opinion refers to an earlier draft, no longer valid. This opinion is regarded as a statement of current facts, which, quite naturally, must lead to misunderstanding. In the latter case, the situation has recently been changed by the introduction of the institution of follow-up opinion. The Commission, Venice Commission, can now issue an opinion evaluating the changes made after the previous original opinion. However, it only does so upon request. It never evaluates the implementation itself. If the opinion is drawn up at the request of the member state, the state is interested in the follow-up opinion. If at request of other entities, it will probably not happen. At the same time, the Venice Commission doesn't take any action to monitor how its reports are used, even when they are used out of context or distort, as it has no competence on this area. To recapitulate, it seems that the Venice Commission checklist coherently reconciles the different systems within the European tradition, decoding elements that are common and universal. The checklist is an objective and useful tool. What is questionable is not so much the checklist itself, but the way it is used. Thank you very much.